name in the chat box. Once the moderator announces Q&A session, your questions will be taken up. If your question is for a specific speaker, you may mention the name of the speaker as well. Alternately, to ask questions, you may click on the hand icon to raise hand, and during the question answer session, your name will be announced and you may unmute and ask your question directly. So these were the basic ground rules. So once again, I welcome you all for today's manthan on quality and productivity dimensions in the legal services sector. For any civilized society, justice for all is one of the fundamental pillars, and for a country with over 1.3 billion citizens, it is a huge task to provide equal opportunity of justice to everyone. A high quality and robust foundation of legal services in the country is therefore essential. Many of you would be surprised to know that India's legal services is the second largest globally, with an estimated market of $1.3 billion. Increasing global interdependencies and awareness are creating more and more opportunities in the legal services sector, but there are several challenges too. It will be the quality of our legal services that will be critical in defining the future path, not only for the sector, but also for the country. We are grateful to have with us Shri R.K. Srivastava, Additional Legal Advisor from Department of Legal Affairs, and now I request him to set up the context for today's deliberation. Welcome and over to you, Srivastava, sir.
Okay, good evening, everyone. I am R.K. Srivastava, Additional Legal Advisor, Ministry of Law and Justice, Department of Legal Affairs. The legal services is one of the important services in India, and not in India, globally it is a recognized services. The proposal of Department of Commerce to give focused attention to 12 identified champion service sectors to promote their development and realize their potential was approved by the Cabinet. One of these identified services sectors, one service is legal services. As we all know that the profession of the advocates in India is governed by the Advocates Act 1961, along with the rules framed by the Bar Council of India, which is the regulatory body for the legal profession in India. India is the world's second largest legal professionals, marked with more than 1 lakh lawyers. Legal service sector in India is composed of three distinct sectors. First, lawyers providing sophisticated, oftentimes cross-border legal work to corporate clients. Second, lawyers providing primarily domestic legal services to individuals and small businesses. And third, LPO, that is legal process outsourcing, which provides support functions such as documentation, review, and legal research. The legal profession is different from other professions in that what the lawyers do affects not only an individual, but the administration of justice, which is the foundation of the civilized society. Both as a leading member of the intelligentsia of the society and as a responsible citizen, the lawyer has to conduct himself as a model for others, both in his professional and in his private and public life. The society has a right to expect of him such ideal behavior. It must not forgotten that the legal profession has always been held in high esteem and its members have played an invaluable role in public life. The regard for the legal and judicial systems in this country is in no small measure due to the tireless role played by the stalwarts in the profession to strengthen them. They took their profession seriously and practiced it with dignity and devotion. If the profession is to survive, the judicial system has to be vitalized. No service will be too small in making the system efficient, effective, and credible. Legal system in India is the natural outcome of its deeper roots in ancient Indian traditions. It has existed in India from the dawn of Aryan civilization. There are also sufficient evidence to prove that legal profession in India existed even when the first British court was established in Bombay in 1672. It existed during the Vedic period, and law has been recognized in our Vedas as dharma. Law, being a living organ, underwent many changes and reforms with the changes in the society. Similarly, the legal education and legal profession in India also underwent many changes, as proved to be one of the best in the world. The legal profession is known as a noble profession having high traditions and has been catering to the needs of the country since long. Thus, the members of this profession are expected to uphold those traditions and serve the society with sincerity and honesty. If such are the expectations from a noble profession, its members must conduct themselves in a way which may be worthy of emulation by doing any act which is contrary to the accepted norms and standards of this profession. A member of the profession not only discredits himself but also brings disrupt to the profession to which he belongs. According to ancient traditions, the professional services rendered by the lawyers were honorary, and the reward given to him was not a compensation for discharge of his legal obligation or legal assistance, but in the nature of gratitude in recognition of the honorary services rendered by him. Among the Romans, it was one of the duties which the patrician as patron owed to the plebeian to give protection to the latter in his lawsuits. For those who rendered legal assistance, Gibbon says in his book Decline and Fall of the Roman Empire, on the public days of market or assembly, the masters of the art were seen walking in the forum ready to impart the needful advices to the manifest of their citizens, from whose votes on a future occasion they might solicit a grateful return. As their years, as these years and honors increased, they seated themselves at home on a chair or throne to expect with patient gravity the visits of their clients, who at the dawn of day from the town and country began to thunder at their doors. However, with the passage of time, professional assistants ceased to be gratuitous with the multiplicity of proceedings, increase in litigation, and complications of law. The legal assistance could not be in the nature of a mere social obligation, and the services rendered as honorary because a great deal of time was needed by an advocate to equip himself with the laws which prevented him from earning his livelihood from other sources. The ancient tradition having ceased to exist, the profession of law could have flourished only if those who pursued it were allowed remuneration for the services rendered. It was Mahatma Gandhi, who was himself a lawyer, who articulated a different role of advocates both in the profession and in society, uniting parties through conciliatory methods, reaching compromises without compromising trust and conscience, winning clients' cases only if it so deserved according to one's own conscience, and keeping the purity of administration of justice. In all that one does was the message of the father of nation to his professional colleagues. You all are well aware that the legal profession in India is treated as an independent profession and is mainly regulated by the Advocates Act 1961. In order to make our laws more effective, to wipe out the tears from each and every crying eye, the bench and the bar has to work together with an intention to work for the objectives of our Constitution. Our Constitution is not to be construed as a mere law, but as a machinery by which laws are made. It is a living and organic thing which of all instruments has the greatest claim to be construed broadly and liberally. The framers of our constitution were keen to preserve the democratic values to which Indians had attached the highest importance in their struggle for freedom. But they were also keen to take provisions considered to be necessary in the light of the social and economic backwardness of certain sections of society. Now it is our turn to protect the values of our constitution to make it more meaningful. Our constitution recognizes free and independent judiciary. Access to justice has been recognized as fundamental right. Justice delivery or administration of justice is one of the paramount functions of the state. We cannot be said to fulfill our social obligation unless we are able to promote justice on the basis of equal opportunity and provide free legal aid. A criminal trial cannot be said to be a free trial if the accused is not represented by a lawyer. We have our legal aid schemes and programs. I urge members of the bar to actively involve themselves in legal aid programs. As you all are aware that pendency is one of the hurdles in enforcing the rights to justice. Hence, in order to remove this hurdle, apart from in the initiative taken by the government, advocates has to play a predominant role. On this occasion, I appeal the bar at large to play a proactive role in mitigating the pendency of litigation. With regard to cross-border issues, today all the businesses are continually challenged to manage the impact of multiple and ever-changing tax jurisdictions. The United Nations, the WTO, and the developed nations of the world have all propagated free trade across all geographical barriers and the enhancement of economic development across all frontiers. The joint policy statements made by the heads of the government of India and the various foreign countries encourage and emphasize the need for cross-border transactions. For this purpose, double tax avoidance agreements have been introduced to prevent and mitigate the hardship that can be faced by individuals and companies alike by having to pay taxes in helping to achieve the targets of overall growth and prosperity. The regional trade agreements have increased the cross-border transactions and paving way to meet new challenges in the tax regime. Hence, the need to tackle cross-border tax and investment issues are necessary. So far as entry of foreign lawyers is concerned, the division bench of the Honorable Supreme Court passed a crucial verdict in the matter titled Bar Council of India versus A.K. Balaji and others, declaring that foreign lawyers are not entitled to practice law in India either on the litigation or non-litigation side unless they fulfill the requirement of Advocates Act 1961 and the Bar Council of India rules. In the petition, the main averments were that to practice law in India, a person has to be an Indian citizen and should possess a degree in law from a recognized university in India. Nationals of other countries could be admitted as advocates in India only if citizens of India are permitted to practice in such other countries. A foreign degree of law from a university outside India requires recognition by the Bar Council of India. Indian advocates are not allowed to practice law in UK, USA, Australia, and other foreign nations except on fulfilling onerous restrictions like qualifying tests, experience, work permit, etc. Foreign lawyers thus should not be allowed to practice in India without reciprocity. This issue arose from the judgment of the Honorable Madras High Court in the matter of A.K. Balaji versus Government of India, as well as the judgment of the Honorable Bombay High Court in Lawyers Collective versus Bar Council of India. Accordingly, foreign law firms, companies, or foreign lawyers do not have an absolute right to practice law in India, and they will be governed by the code of conduct applicable to the legal profession in India. Practicing of law includes not only appearance in court but also giving of opinion, drafting of instruments, participation in conferences involving legal discussion. The scheme in Chapter 4 of the Advocates Act makes it clear that advocates enrolled with the Bar Council alone are entitled to practice law, except as otherwise provided in any other law. All other can appear only with the permission of the court, authority, or person before whom the proceedings are pending. Regulatory mechanism for conduct of advocates applies to non-litigation work also. The prohibition applicable to any person in India other than advocate enrolled under the Advocates Act certainly applies to foreigners also. Although in the last 4 decades, national and international legal policies and rules concerning trade and investments have repeatedly changed, the investment and its varieties have also undergone substantial transformation in its magnitude and content. In the national laws and policies, the trends towards liberalization and increased protection have gathered strength, and the control and restriction have been relaxed in many countries. Non-discriminatory treatment after admission of investment either by way of FDI or portfolio is becoming the rule rather than an exception. However, so far no international investment related dispute has been raised against India, and this glaring speaks the effectiveness of investment agreements concluded by India. But law, being a living organ, has to grow in order to satisfy the needs of the fast-changing society and be abreast with economic developments taking place in the country. As new situations arise, the law has to be evolved in order to meet the challenge of such new situations. Law cannot afford to remain static. We have to evolve new principles and lay down new norms would adequately deal with the new problems which arise in highly industrialized economy. Ministry of Law and Justice, Department of Legal Affairs is closely monitoring the situation and working with all concerned stakeholders to address the issues of the cross-border legal challenges, including the entry of foreign laws. Thank you. Thank you.
Your mic is on mute. Still on mute.
Is it audible? Hello?
Yes. Yes.
Thank you, sir, for setting the context for today's Manthan on legal services sector. With this, now I invite our moderator for today's session, Professor James J Nadamparam. He is professor and head of the Center for Trade and Investment Law, CTIL, established by the Ministry of Commerce and Industry at the Indian Institute of Foreign Trade. He has been the founding faculty of Jindal Global Law School. Professor James received his PhD from National Law School of India, University, Bangalore, and holds graduate degree in law from Cambridge University, UK, the New York University School of Law, USA, and the National University, Singapore. He has appeared in various WTO dispute proceedings as part of the Indian delegation. Welcome you, sir, and over to you.
Sir, you are on mute.
So thank you, Pooja. Thank you, Dr. Srivastava, and a welcome to all the panelists who have come here in order to participate in this extremely important dialogue on legal services, especially from the point of view of enhancing the productivity and the competitiveness of this very important sector. As Mr. Srivastava mentioned in his opening and context-setting presentation, the legal services sector is perhaps the most important or one among the many important sectors for the country as a whole. And now this sector is also becoming part of trade negotiations. We know that in some of the free trade negotiations, even in WTO, this is actually perhaps one of the covered sectors. So with that particular background, I would like to invite the esteemed panelists to give their pointed interventions. I have prepared a set of questions to all the panelists. So we have got around 12 panelists, and this is actually taken from a cross-section of this extremely important sector. Some of them are leading litigators. Some of them come from the non-litigious sector. And we also have got people from the academia. And in addition to that, we have people from the in-house legal departments as well. So it is a very good cross-section of some of the leading experts in their own right. And we hope to actually contribute to the debate happening with respect to the legal services. So to give a brief introduction about the panelists, it is not in any particular order, but I would like to introduce Dr. Lalit Bhasin. He is a leading advocate and litigator. He is also the Central Governing Council member of the Services Export Promotion Council and a managing partner of Bhasin and Company. We have Mr. Manas Kumar Chaudhary, chairman of the Association National Council for Competition Law, and is also a partner at Khaitan and Company. And he is actually head of the antitrust practice. He advises Indian and foreign clients on competition law and related legal and regulatory issues. We have Dr. Harpreet Kaur. She is actually a professor at the National Law University in Delhi, specializing in the domain of commercial laws and teaching corporate law, securities regulation, and competition law. We have Mr. J.P. Madan, the founder of Madan Law Offices, a law firm based in Delhi. He is also involved in the legal advisory, litigation, and arbitration practices. Then we have Mr. Rajendra Prasad Singh, who is a director, HR and legal of the Indian Farmers Fertilizers Cooperative Limited, and is involved with the formulation and implementation of HR policy and strategy, legal due diligence, corporate legal strategy, and litigation and arbitration. Then we have Dr. Sanjit Gamawat, who is an executive director, legal and group company secretary, Dalmia Bharat Limited, and has nearly 3 decades of experience as a head of legal, taxation, risk and compliance, regulatory, corporate, secretarial functions of corporations and MNCs across industries. Let me also introduce Mr. Vineet Aneja, founding and managing partner, head of corporate commercial practice at Classes Law, with experience in a range of areas, in particular advising foreign companies in relation to their investment in India. Then it is my turn to introduce Mr. Anku Srivastava, who is a managing partner with the ESY Laws and has a large experience in the range of mergers and acquisitions, capital markets, real estate and labor laws. Let me also introduce Mr. Manoj Bharadwaj, who is an executive secretary at the Indian National Association of Legal Professionals, INALP, and is a strategist specializing in international trade and investment, climate policy and governance, education strategy, and foreign policy. The next is Mr. Sachin Kalra, who is a deputy general counsel at Hindustan Times Media and has a focus on litigation, arbitration, advisory, contract management, and team management. Then let me introduce Mr. Sumit Agarwal. He's a partner at a Surya & Company, a major litigation firm, and works in the sectors of banking, finance, intellectual property rights, and compliance. Then we have Mr. Sugesh Misra, who is an advisor law at the Competition Commission of India and has appeared in many litigations on behalf of the CCI and writes and speaks on various issues related to competition law. So it is my feeling that I haven't left out anyone because we have got a fairly long list. So, given the fact that we have just an hour and maybe 20 minutes for the discussion and that we have got 12 eminent speakers, let me actually start with perhaps the senior most in this group, Dr. Lalit Bhasin. So let me request Dr. Bhasin to give an assessment about the development and evolution of the legal services sector, which includes the litigation, corporate legal sector, and in-house counsel. Sir, can you just give a fairly broad overview of the sector and the challenges and perhaps the opportunities for reforms? Dr. Basim, can you hear me?
Yeah. Sorry. Thank you, Dr. J Nadamparam, and also I thank Mr. Amit Singh and Pooja Shukla of the QCI for organizing this very important webinar. Although I think we'll be doing only a lip service to the subject in view of the fact that we have only 5-6 minutes allotted to each speaker, in which we cannot deal effectively and appropriately with the important topics which are assigned to us. Therefore, my presentation will be in the nature of giving you the bullet points, not the exposition, you see, about the topic, which is a very important topic. And as I said, that we have been doing lip service to the cause of the legal profession, and what Pooja rightly pointed out in the beginning when she made introductory remarks, justice for all. Now that is enshrined in our constitution in the preamble itself, that we have to give justice, that is social, political and economic, to ourselves by means of our constitution. Has that happened? I can say with some daring certainty that it has not happened so far as the citizens of this country are concerned. There are nearly now 4 crore cases which are pending in different courts of India. What is the government doing about it, you see? What steps are being taken by the government and the judiciary? We have too many laws, overlapping laws, outdated laws, and they are in place. There are no steps being taken to rationalize these laws and to bring, you see, into existence some semblance of reasonableness so far as drafting of laws is concerned. Therefore, effective steps have to be taken. When I say that there are nearly 4 crore cases, there were 3.5 before the pandemic started. Now the number has gone up to 4 crore, for the reason that the cases are piling up during the pandemic period. There are virtual courts. Everyone is taking credit for virtual courts. The government is taking credit, the judiciary is taking credit. But what is happening? Are these cases being disposed of at the district level? Only the Supreme Court, you see, some important matters are taken up every day, and after lunch they generally don't hold the sittings. Same thing is happening in the high courts. Important cases to be decided by the registry, what is important, what is not important. Those matters are taken up. What about the cases of the ordinary citizens of this country? And we talk of justice. It is very strange. I am glad that we have a very senior representative of the government here. Well, what steps are being taken to provide this justice with these areas? Anyway, my topic is, you see, that how do I assess the development and evolution of legal services in litigation? As I've told you, there is a complete breakdown so far as litigation is concerned. There is no development at all. If at all, there is a deterioration so far as litigation is concerned, because our citizens are not getting justice. That is because your emphasis is only on law, not emphasis on justice. Litigation is at the verge of collapse, and that is why people are talking about ADR, the alternate dispute resolution. Is it an effective mechanism to replace litigation? Again, with great sense of sadness, I say no, because even arbitration has not taken off. If at all it has taken up, it is only in those cases of multinational companies or big commercial disputes which are there in the which arise in the commercial transactions. So, what is the remedy? And if at all, that is where the government, the judiciary, and the legal profession can help, is mediation. I always tell my clients, and I speak repeatedly about it, that a bad settlement is better than successful litigation. Therefore, we have to encourage mediation, and that is where the role of the In-house counsel also comes in, you see. They play such an important and significant role. If at all there is some positive feature so far as the legal profession is concerned, that is provided by these two segments. The first segment is the law firms and second segment is the in-house counsel. We have seen a tremendous growth so far as the quality and quantity of the law firms in India is concerned, particularly after liberalization started in 1990s. Our law firms are second to none. They can compete with the best. But now again, as Mr. Shrivastava said, referring to Balaji's case and all that, Supreme Court says that you amend the law, bring the foreign lawyers, you see, so that there could be healthy competition. But 2 years have passed after that judgment was given. No steps are being taken to amend the Advocates Act. Initially, the legal profession opposed the foreign lawyers, but now we are supporting the foreign lawyers and supporting the Ministry of Commerce initiative in this regard that please allow foreign lawyers. But as per Supreme Court judgment, only Indian citizens can, you see, practice law in India. Therefore, what is required is firstly the amendment of the law. And that cannot be done by judiciary, that cannot be done by legal profession, that cannot be done by bar council. Therefore, only the government and the parliament can amend the law. Therefore, I request, you see, the worthy representative of the government of India to pass on our views. And corporate law firms, the corporate practice has gone up considerably and qualitatively also. And as I said, we are second to none. But the most important role is being performed is by the in-house counsel, on whom, you see, lies the great responsibility. They are actually the backbone at the moment of the legal profession, for the reason that you cannot have bilateral agreements, you cannot have joint ventures, you see, you cannot have until and unless the in-house counsel, you see, gives the appropriate support, legal support. Therefore, the role of the in-house counsel is developing, and I am very happy to see, as the president of the Society of Indian Law Firms, that the in-house counsel are qualitatively very superior also, because they are either the topmost law graduates from the law schools, or they have been in actual law practice very successfully in commercial matters. Therefore, they are playing a very pivotal role along with the law firms. But so far litigation is concerned, I think there needs to be a lot of in-depth thinking and introspection by all the stakeholders. So this is my broad overview. I hope I have not gone over the time allotted. Thank you.
So thank you, sir. Thank you, Dr. Bhasin, for the very insightful comments. Although you have painted a fairly grim picture about the litigation sector, you have pointed out some of the positive sides, mainly with respect to the corporate practice and also the in-house sector. So now let me turn to an academician, Dr. Harpreet Kaur. So my question is that from the perspective of an academician who studies and examines this sector, can you outline what quality and productivity mean for the legal services sector, and especially how they are actually interlinked? The second question is that are the law schools, mainly the national law schools and the new generation law schools, contributing to enhancing productivity and quality?
Thank you, Dr. James, for giving me this opportunity for speaking here with the esteemed panel members here. And my thanks to QCI members who have organized and the representative of government, Mr. Shrivastava. It's a pleasure to speak on quality and productivity of legal services from the point of view of an academician. And I will look at the quality and productivity of legal services from the lens of two major consumers of legal services, who are business and the common man. And both of them, they look forward to get the dispute resolution and access to justice through the services which are provided by the law firms and the individual lawyers. If I go into the description of the terms quality and productivity, and all of us will agree that both of them, they emerge from the umbrella concept of efficiency. And if I look at efficiencies, how many types of efficiencies can be attributed to the legal sector, legal services sector? First of all, most important will be the economic efficiency, which means that how much cost and time is involved into getting a dispute resolution, which has also been indicated by Dr. Lalit Bhasin. Then comes the professional efficiency, which means that what is the standards of skills of the lawyers and the standard of services provided. Third is very important, known as ethical efficiency, that how much transparency and accountability of the professionals is involved. Then the social efficiency, that whether we are able to provide equitable and ready access to legal services. Then the second last will be innovative efficiency, which is very important in view of the technology and other innovations, that whether we have the ability to adopt and innovate both the services as well as the mode of delivery of services. And the last is the outcome efficiency, that what is the level of the satisfaction of the consumer of legal services. Now, in this background, when I got the invitation, I had informal discussions with few businessmen, ranging from small, companies to some of the high-profile, companies also. And all of them, they indicated some points which I thought that I should include in my presentation. They said that there are certain systemic changes required. For example, are we in a position to disseminate knowledge about law to businessmen? Right? Is there any way that the government is disseminating that information, that how many laws are there which are applicable to any particular business? Right? Like ready reckoners. Are we looking at a regulatory coordination? Because there are so many regulators. If you look at mergers, from the company's approval to NCLT to CCI's approval, so many regulators are involved. So are we looking at coordination or streamlining of regulatory processes? Can there be a way that we can have standardization of returns which are filed before different regulators? Can there be any way to get easy explanation of government notifications? Because all of that will help the business to ensure easy compliance, like all legal compliances. The second point which emerges is, can we talk about standardization of legal services? And I'm happy to share that BIS has already undertaken this process of standardization of legal services. Now, what do we mean by standardization of legal services? Can we have standardized operating procedures, for example, for mergers or restructuring? Can we have standard forms, formats by use of technology? Third point comes, can there be a chance of standardizing legal practice before courts or tribunals? I know it's a very important area where everybody would not agree to it. But we have seen that COVID-19 has given us hints that where we referred to e-filing, e-codes, where we also referred to general meetings through other audiovisual means, which we never thought that will be possible for Indian companies because we were not mentally prepared for it. We also know about case management hearing, which is provided by Commercial Courts Act. We can also include something about judicial infrastructure also under this act. And coming to fourth point, which is about alternative dispute resolution mechanism. Is there any way that we can talk about certification of arbitrators or mediators now? Because mediation has also been now emphasized a lot, even in Consumer Protection Act, it has been added. Now, coming to the contribution of law universities, there are two contributions which we make. We produce new lawyers who are equipped, skilled in research as well as procedure, right? I will come to this point a little later. There is another way in which we can contribute is providing continuing legal education. But we are not able to do so because there is no requirement of continuing legal education in our country. Although the Department of Justice for commercial dispute has reached out to certain universities, 4 or 5 universities, for bringing short courses for continuing legal education, for example, on business and commercial laws. Now, coming to production of new lawyers, we give them so many new courses. We train them in substantive laws. We give them interdisciplinary courses. We offer clinical legal education. Although I understand that we offer clinical legal education in 4 areas which have been prescribed so far, which includes drafting, conveyancing, professional ethics, but we need to add more clinical education. For example, in the corporate laws, we may establish clinic on investments or mediation clinic we can do. And how for systemic changes academicians or universities can contribute, we can provide excellent resource for research, for undertaking all the standardization process, right? All developing all the standardized operating procedures, dissemination of business law related knowledge to businessmen through preparation of relevant documents and conduct trainings. But the caveat here is that we need financial support for it. And the law universities, I'm not sure how many of you are aware of, that we do struggle for financial support, right? And we do work very hard for producing, good lawyers, but we need support for participating more in the legal services through the research that we can provide and also through the trainings that we can conduct for different legal services. For that, definitely we need support. And in the end, I would also like to say that there is a need for involvement of academicians in policy making also. We know that IIMs and IITs are preferred, but academicians of law universities should also be given, and other universities should also be given a platform to be part of the policy making. And this is what is my contribution to this panel as an academician, and I'm open to questions. Thank you so much. Thank you.
So thank you, Dr. That was a very useful perspective. I think you touched upon 2 important things. One is actually the fact that standardization is extremely important for quality enhancement. And second, the fact that there is a certain amount of disconnect between the legal academia and the practice. And obviously the fact that, continuing legal education is extremely important. Perhaps I think we need to, skill and reskill the lawyers over a period of time. I think it is high time that we have to think about continuing legal education, which can be a mode of, revenue collection for the universities as well. So that's a very, very valuable input. Let me now move on to Mr. Sumit Agarwal. So with the Surya and Company, are the Indian law firms able to leverage their intellectual property rights adequately in India? And what are the constraints and bottlenecks in this regard? So do you think that partnering with the foreign law firms is an effective way to improving the capability of Indian law firms to deliver better quality services? And secondly, this is actually maybe slightly unrelated issue. Do you feel that the current restrictions or curbs in advertising could stifle the growth of the legal profession in India?
Thank you, Dr. James. I hope I'm audible to everyone.
Yes, you are.
Yeah, thank you. Good evening to all the fellow panelists and speakers, as well as all the ones who are listening to this webinar. And Dr. James, you've raised a very, very important question here, that are law firms as of today able to leverage IP? And I think it's a question which is, if we look at the law firm structure itself, and Dr. Bhasin very kindly put it, but I'll take it a step forward. Today, one of the biggest questions is that law firms as structures, as organizations within India, we are not even formally really recognized as an independent body altogether. We are all practicing lawyers who come together and create a firm. And that's how we are operating as a group. And of course, in the past, law firm and law firm structures have always existed, but they have been based upon the traditional models of either a proprietorship, where you would have certain other partners come in and join in, and partner was more of a rank. And now we, of course, have certain structured LLPs, but the percentage of people who are involved in this is very, very limited. I think the contribution of the total number of lawyers who are within this country and organized within the law firm sector itself is quite much in significance, and it's limited and restricted to most of the metro cities. And we look at Delhi, Mumbai, Bangalore, Calcutta, and if you would just take away these 4 or 5 towns, beyond that, the whole concept of a law firm is not very organized. But since you talk about IP, I wanted to first take a perspective and share something about intellectual property as an area, which quite frankly has been in India, but it was very selectively practiced by most professionals. And these were people who would deal and cater to certain limited industries. So we had trademark work, which had largely got to do with FMCG sectors. And then you had copyright related work, which was emanating out of our entire entertainment and music industry. But firms themselves, have they actually really developed intellectual properties of their own, which is templates or systems or methods? This is something which has formally never been heard of. And it was post the liberalization era when India as a market, as an economy opened up to the world. That's when we were soliciting foreign investments. That's how the whole concept of IP really drove into India as an industry. And firms got set up, and these were largely in the non-litigation side, which is on the corporate side. And you had firms which were getting into advisory. They were getting into new areas like diligence. They were getting into areas like creating standard documents, whether they were for manufacturing, whether they were for franchising, and so on and so forth. And a lot of these processes were based upon person-to-person relationships. So actually it was that whoever was having a small setup and happened to be in connect with one of the foreign entities or had a good local goodwill at that point of time, they were approached and they were really asked upon to do work. And then while they were working with the foreign firms or with foreign in-house counsels or with the larger MNCs, they developed greater practices. So today, I don't think there is a system for firms to leverage IP. And it is quite unfortunate purely because firms still cater towards customizing systems. They are not having even trademarks registered in their own names at this point of time. And I can tell you from my experience as an IP practitioner, very active in the trademark side, that not more than 100 odd law firms or lawyers actually even register their trademark with the trademark office at this point of time. But IP as a sector was truly one of those global sectors which has opened a lot of avenues. And while I understand that we talk about quality and productivity in general, the trademark regime, not just a trademark, the entire IP regime in India, in fact, has been now currently based upon what is the WTO standard. So post-liberalization, India got very actively involved in the final rounds of the GATT negotiations. We are one of the original signatories to the TRIPS agreement as well. And as we decided to implement new systems, our IP laws today are entirely in line with what they are globally. And they have provided a very good opportunity for businesses in India and even for enterprises to come up with an IP mechanism where they create intellectual property. That means they're not just implementing or following a technology, but creating one. And today, as Bhasin Saab said very clearly, there is a huge capacity which has been built up amongst Indian law firms, which are able to provide various services. These services can be on the corporate side, advisory side, standard documents, a lot of these things where structuring and other advisory roles can actually become a serious revenue earner for the country. There are firms which have managed to break that lead. We have now, thankfully, in India, certain tiers of firms. So you have tier 1 firms, tier 2 firms. There are some firms which are doing admirably well. But even the best of the law firms today are yet to probably be, in terms of revenue generation, in terms of global practice presence, they are not even 1/10 the size of sizable firms which are there in other countries. This does raise a very important question that can we partner with law firms? So if there is a need for skilling, so you've just asked this whole idea that if we were supposed to create India as a law firm market, a legal services market where people from anywhere in the world can come to India and get certain services, the practice areas for these services will be limited, unfortunately, because of course each country and each jurisdiction will have that. But there is a very big ability for Indian law firms to partner with certain Asian countries and other countries with whom we share similar skill sets. But at some level, we would need to have some sort of tie-ups with foreign law firms. But this has to be done within some amicable and a very clearly well-defined rules. Again, reciprocity, which was discussed earlier, is a very, very important aspect. And at the same time, I think we are not intending to give away the position which we as law firms are taking through Society of Indian Law Firms. And we are asking the government to come up with a better policy, a better refined process, so that within those guidelines, this industry can flourish even more. Coming to the point of impact or restrictions on advertisement, this is something of an unrelated question, yes, but I'll be very honest. Today, we are at a point where there is need to look at the Advocates Act and look at what is it that will constitute as advertising and what will constitute to be participation by foreign law firms. So would a collaboration with a foreign law firm to exchange skills, maybe an Indian law firm sending 2-3 lawyers down to London and have 2-3 lawyers from London come down to India, would that seem to be a plausible way to go in the future? But quite frankly, it requires clarity in policy, because unless and until the government wants to encourage us, I think this would not be achievable. And I do feel that somewhere deep down, Indian firms are right now largely growing around a single perspective, and that is to look at what is the trend and where the clientele is, what the client is demanding. And the client's demands are really creating the evolution of the Indian law firm. And to me, this is not a healthy trend, purely because clients' demands are based upon multiple aspects. This could be global trends. It could be the fact that Indian market or Indian economy is still seen as a growing economy, and so many other reasons. But we should not be limiting ourselves to that. There should be an ability for the Indian market to become a very truly global market for legal services. And one of the areas which shows a reflection of why India has not been able to develop that neutrally is in ADR, for example, arbitration centers. So we see locations like Dubai or Singapore, which are offering arbitration centers or just arbitration processes. And they've been able to attract a lot of dispute resolution happening under ADR, under SIAC or LCIA, or in Dubai's case under the DIFC. And the Indian arbitration market has not been able to attract the same skill set. And I think that's purely because the firms are still largely focused upon answering or catering to what the clients are simply asking for. And we've not been able to develop and evolve our own IP or leverage our own IPs. We're not focusing on that at all. And a little bit of more clarity from the government side, where the government is wanting to promote legal services as an industry by itself so that we can become global level service providers. I think that is something that would really help and go a long, long way in facilitating the industry. So that's what I want to contribute. I know there are a lot of other speakers who will talk about other subjects. So over to you, Dr. James.
Thank you, Mr. Sumit. In fact, it was a very structured responses to all my questions, including the unrelated question. You have basically, very clearly explained the fragmented nature of Indian legal services and the fact that law firms are basically limited to some of the big cities in India. And the second point, that the Indian law firms are actually evolving based upon the client demand or the client requirement rather than taking their own initiatives in terms of developing IPR. I'm sure anything that is worthwhile and valuable can be commoditized. Or maybe you can have some, it can be even converted to something like a capital. So that is why the intellectual property rights form an extremely important component in the future evolution and growth of the sector. Thank you for touching upon all these issues. I'm sure many others will also, bring in their own perspective on that. So now let me actually turn to Mr. Manas Kumar Chowdhury and partner with Khaidan and Company. So this is something which is related to the first point which Mr. Lalit Basan was mentioning. He mentioned that we can actually deliver justice with a huge amount of arrears. So the one question is that whether the delay in justice has actually resulted in some kind of an erosion of confidence in the justice system. What structural reforms are essential in the legal services sector to ensure a reduction of litigation time? Then the second question is actually with respect to his own domain. He is a competition lawyer. So my question is, how does improving competition affect the productivity and quality in the legal services sector?
Thank you, Dr. James, and thanks to QCI, Department of Industrial, DPIIT, and all my fellow panelists, and to everyone who is going to listen to me patiently, because I'll try to confine myself within the time. So the questions are very, very interesting and very timely. Structural reforms, in fact, have started in India within the span of previous 20 odd years, rather 30 odd years. With the introduction of economic liberalization, definitely the regulatory mechanism has created a structural departure from the normal courts. Question then arises, if I turn back from the SEBI 1992 until say about the Competition Act, I'm not getting into RERA. I find that in the regulatory space, the challenges are even far more complex than the normal courts, because we have the challenge of institutional memory loss. We have the challenge of domain experts not manning the regulators. We are not finding people with the normal tenure, which is provided under the legislation. Most of the regulators are not able to even complete their normal tenure of 5 years. So this institutional memory loss has not been arrested by government. And this has been a perpetual problem with regard to the regulatory space. We all are aware that this regulatory space is also having a specialized tribunal, which is the first appellate court. Again, the problem of domain experts and not having the right people at the right place. Finally, when this statutory appeal goes into the Supreme Court, they already have backlog, as Dr. Vaseem said. Now, with the added problem of a regulatory appeal coming to them, without people having the domain experts to really had overseen it properly, with the institutional memory loss challenge, where are we heading towards? We have created a structure to minimize the waiting period in the courts by creating the regulatory space after the economic liberalization. And as on 2021, if we look back, we find that we are actually back to square one, maybe perhaps worse than the civil courts. Are we really heading towards a situation where this institutional memory loss and some of these problems would continue, and the process of minimizing the waiting period in litigation has not really been achieved? I'll give you an example. In May of 2017, NCLAT and the former Competition Appellate Tribunal was merged. Now today, from 2017 May, and today I am in January 2021, if I look back and compare with what the COMPAT was used to do, that is the Specialized Competition Appellate Tribunal versus the NCLAT, the number of appeals being disposed of by NCLAT is almost on our fingertips, maybe 2 or 3 in 3 years or 4 years. COMPAT was able to dispose of matters at a faster pace. So by amalgamating the tribunals, making a structural change, did we really achieve the target? The answer is no. So sometimes, structural reforms are not really been thought through previously, and all of a sudden it has been done, causing much more problem and uncertainty. And you imagine in a space of competition law, in fact, Indian competition agency is competing with 130 other competition agencies in the world. So how are we really shaping our future with regard to this specialized regulatory space? as you had said, how do you minimize the time, reduce the time in litigation? I'll tell you, again, I have got statistics to show. 26th May 2017, NCLAT and COMPAT got merged. NCLAT is now burdened with IBC matters, and COMPAT work, that is the competition appeal work, has gone into the back burner, and we do not even get an opportunity of being heard. Either there is a overload of IBC matters, NCLT matters, and the competition matters are getting the last priority, and we are not getting any disposal of matters. On the contrary, if you see the intent of the regulatory laws, they actually aim at minimizing the civil court work, giving a predictable disposal of matters, and on the other hand, what we have found delays. So this is one area I think if you are suggesting to government, there should be a predictability in appointment. The person who are appointed must have a pre-domain knowledge or a training thereof, and they must have a predictable tenure. It should not be for 2.5 years. And the moment the member and the chairperson demits the office, immediately there is an institutional memory loss, and the person who subsequently joins starts de novo. So that is what is a mismatch between the regulatory mechanism created after economic liberalization and then what we wanted to achieve. That's one area. The second question of yours has already been answered by my senior Dr. Lalit Bhasin, that after the entire legal fraternity had actually agreed to having the entry of the foreign law firms, why it is not happening? So to my mind, as a competition lawyer, entry barrier, exit barrier are the worst form of anti-competitive concepts. So if we are able to innovate by introducing the overseas lawyers, we will be threatened to survive. Either we raise ourselves, our bar to that level, or we diminish, or we finish. So that is what, as you ask me as a competition lawyer, what would you suggest? I would suggest that government should seriously think about making the foreign law firms an entry into India, and let us be competitive in that regard. There should not be any barrier to entry of a foreign law firm because, in all sectors of India, the entry has been allowed. And as you read the competition law, it is both talking about production as well as provision of services. We are, of course, as lawyers giving the best of the services, knowledge services. But let's also compete with our competitors across. It may so happen perhaps we may beat them in our knowledge and acumen. As Mr. Bhasin said, that there is no dearth of talent in India insofar as the legal services are concerned. And I tell you, as one of our speakers did mention, that the Indian law firms and the Indian lawyers are not anything second to none in the international competition. Why not that happen within India? So as a practicing lawyer of competition, since I believe, Enterprises Act 2002 of UK, they do also make the lawyers as part of their stakeholders. And in our law, that is in our competition law, even the provision of services include professionals. If I just extend this argument to professionals, everyone is covered under the Competition Act. So my takeaway from this wonderful discussion is we should make less of barriers into the market. We should make the achievement of the regulatory space predictable. There should not be institutional memory loss. The members and the chairperson must have at least the number of years of their tenure as prescribed under the legislation. They should not come for 2.5 years, and in the process, the whole jurisprudence fails to develop. These are my some limited points, but I would be happy to answer questions because due to constraint of time, I can go on for quite some time, but I do not like to do so. I thank Dr. James for the questions. Thank you.
So thank you, Dr. Manas. In fact, you have also touched upon a number of important issues. So in the trade law parlance, we actually call it a sequence liberalization. Once we open up a sector immediately, then perhaps, the domestic sector may be completely swept away. That is a danger. So sometimes, you have to prepare your own domestic industry or maybe the sector in order to face the competition. Some of the other
So you are muted.
Okay. So, I mean, with respect to the structural reforms, I think your points are extremely valid because, we wanted to reform the sector, but somehow the changes that were introduced backfired or haven't actually yielded the desired kind of an outcome. Very important points. So maybe I think we can also take the views of some other people in the panel and take it forward to the government. Because another important point which you mentioned is that even the Indian Competition Authority actually competes with 130 other agencies in the world. That is something interesting, because in a modern world, nobody can actually stop competing with even entities outside the country. So that is actually a phenomenon associated with globalization. Very interesting points of view. So let me actually now bring in Mr. Sachin Kaldra, working with the Hindustan Times Media. So it is a fairly straightforward and short question. Sachin, can you actually outline the major challenges faced by the Indian legal services sector, especially from a business point of view?
Thank you, Professor James and QCI team, and along with Dr. Labasin here and all my panelists and learned members, participants herein. Mr. James, your question was very straight, but I want to take out some time towards the business perspective, which we want to look into as an in-house lawyer. Mr. Bashin also talked about that. As an in-house lawyer, I personally feel being an in-house lawyer, we need to be, as company secretary, also a lawyer should also be given a chance as a business lawyer, that he should also be given an identity towards that, which my Advocates Act required a major amendment now. That's amendment requirement is there, either in it can be an Advocates Act or it can be otherwise also, that there should be an identity to a business lawyer given towards being a lawyer who is giving a business solutions to business, basically. Apart from the law firm lawyers are there. So as a business lawyer, I am also running a law firm, which is there, a small law firm which comes into the business houses, wherein I personally, or a business lawyer is personally responsible to giving all regulations, practicality, approaches, litigation, arbitration, everything which comes under the feet of a lawyer. Now the question which you have talked about, what challenges legal services or in-house counsel or business lawyers are facing towards the legal industry today. A business, basically, to run a business in India, which I personally feel there are a lot of challenges which comes towards the business side. There are 180 to 200 compliances when a business has to start with. 280, 200 compliances to cover around by one team or by a business houses is a big challenge, which I personally feel. A challenge towards Companies Act, challenge towards, we can say, GST, compliances, challenge towards the compliances. There are a lot of compliances which comes under tax compliances, comes under labor compliances, multiple compliances, multiple houses which a person has to visit and get the compliances done. Maybe the government may be looking into an online compliances system which is available, but even though that fails when it comes to a day-to-day compliances part. So compliance issues needs to be tackled properly by the industry of specialists. One. Plus, there's need a change in structuring which is there from the government side, that yes, these are the compliances, mandatory compliances. One form filled together with the compliance part needs to be filled and get to the legal industry. Yes, this has been done with a low cost. Cost to the compliances are going high with the companies, and with the small houses, the startups, really they can't compete with the high. I'm telling you, they can't lead towards that liberty, giving up big houses the compliances part and getting it done, because cost toward compliance is very high. Second, most important thing which business team is struggling today is the litigation side, wherein I tell you, if I personally give my practical experience, if I had 100 cases a year, out of 100 only 2 cases are being resolved. Why? Because dispute resolution is so delayed that the purpose of litigation goes down in a couple of years. The debts which have been increasing for the houses is very high. There needs to be some system alternative available. Lot of works been given. If I tell you for a commercial dispute, you need to have a mediation before starting a commercial dispute. But even mediations becomes non-starters. Out of 100, it only two turns into a mediation settled. Other than 98% goes to a non-startup. That's a big challenge which we houses are facing today. Plus, control on IP policies needs to be strengthened. Basically, protection of IP is not so easy. Basically, IP protections, basically, which I personally feel is very costly today in India, need to be reduced. some pressure needs to be reduced towards that also. Small houses having an IP, getting an IP is well within time is also a question mark. It also get delays. It like rightly said by Sumit and earlier also. Change in system is required basically. If I tell you copyright board from 2012 to 2020 was non-operational. IPIB got introduced by the month of August 2020. Now again, with the term getting over our chairman within two months, it will go away. A lot of questions, a lot of concerns comes up when it comes to settlement and closures of matters basically which are there. Which is making all business houses and uncertainty is there. And we as a lawyers basically or as a business houses, what we look from the legal services is that dependability, a certainty of answers which is required, which is not getting into a process till date. Plus, a lot of policies which are there for business houses which needs to be changed basically. A lot of old policy still continues. Like I tell you, my radio division started in 2004 and 2010. There are a lot of policies being implemented from 2015. Now a lot of changes need to be seen up as per the business structure which is changing. You see, you see the telecom companies are going day by day, getting into strong losses day by day. Why? Because a lot of regulations are there, which are old regulations need to be changed according to the market shares, the market revenues. This is what the structures business houses are looking into. Other than there are a lot of laws which needs amendments right now, which I personally feel, seeing the scenarios, even if arbitration got changed, the 12 months arbitration will be completed, but I am not able to see that really that is working around. I personally have got a lot of arbitration which is running new arbitrations. We've been for 2 years now after amendments also. So there are a lot of things which I as a lawyer need to look into, but similarly government need also into the how to support a business basically. Support to business is must basically to sustain the house also. That is what from my side, Dr. James and all. Thank you. Hope I covered your portions also.
Yeah. So thank you, Mr. Sachin. In fact, again, very useful. You have identified some of the major difficulties, I think, experienced by the business firms, especially from the point of view of the regulatory compliance, the instability with respect to the laws, and also the fact that even a corporate in-house department is almost like a captive law firm. So with the various challenges which are common to the law firms are also in a way applicable to the in-house department. So thank you for pointing out all these things. My next question, panelist will be Mr. Madan. Again, this is actually a question related to the structural reforms within the legal services sector. The question is, especially given the functioning of the NCLT, the National Company Law Tribunal, which has got wide jurisdiction over corporations in India, and they have got a significant amount of control and jurisdiction. So, Mr. Madan, do you think that the infrastructure that we have provided to some of these tribunals, in terms of the personnel, the judges, the lawyers, and the infrastructure, have the capabilities and the skills to administer, implement, and interpret these kind of advanced and sophisticated laws?
Thank you, Dr. James. If you ask me that as on date, if I am satisfied with the present infrastructure which is there with NCLT, my answer is big no. But if you ask me about the future, I'm very, very optimistic and positive, particularly from the lawyer's point of view. As far as benches are concerned or infrastructure is concerned, certainly the government has to do of its bit. But from the lawyer's point of view, I'm very, very optimistic. As your own document said that we have 1,300 plus recognized law schools. Increasing number of fresh lawyers are joining this kitty every year. And we are looking for a robust legal sector in the years to come. We have the lengthiest constitution in the world, and judiciary, no doubt, is proactive at certain places only. And we have internationally renowned lawyers like two present here, Dr. Lalit Bhasin, Mr. Manas Chaudhary. We have internationally renowned general counsel, in-house counsel like Dr. Sanjeev Kemawat and Sachin Kalra present here. Renowned academician like Dr. Harpreet Kaur and others present here. So when these lawyers, these experienced professionals, these academicians who are there I tell you, I'm very positive, particularly because of this pandemic. You know what has happened? Since till today, what we have observed is that lawyers from the students from the top law schools, they go to they get better jobs, better assignments in the corporate sector. But because of this pandemic, the world is open for all. Even this revised access to resources. Even a student while sitting in a village is now having access to not only the domestic resources but also international resources. I remember only last month in one of the international program which went over for I think 30 days, people from across the country were attending that event. Even some of the students, I tell you, were sitting in their village in the fields, and they were having access to that particular program, particular event. So, and now all the law schools, all the colleges, they have started inviting even the internationally acclaimed professors, adjunct faculties. So as far as lawyers are concerned, I'm very, very hopeful that in the years to come, we are going to have very, very strong candidates. We will be having a deeper understanding of the most complex and diverse and emerging laws, not in the country, but across the globe also. But yes, while coming to the other infrastructure at the tribunals, particularly NCLT, I'm having my own reservations there. You know, this NCLT was constituted under the company law for the purposes of Companies Act by Companies Act 2013. Then in the year 2016, we saw this Insolvency and Bankruptcy Code, and under the Insolvency and Bankruptcy Code, the adjudicating authority for the purposes of corporate sector, NCLT was declared an adjudicating authority. When NCLT became reality, you know, entire company law board work was assigned to NCLT. High Court M&A was assigned to NCLT. High Court winding up was assigned to NCLT. Even Sikh Industrial Companies jurisdiction of BFR, IFR was assigned to NCLT. So this was called consolidation of corporate jurisdiction. So even the benches were not capable of handling that work over and above this. IBC came, and IBC, under IBC adjudicating authority is NCLT. Then comes 2017 and 2018, and what we saw that various notifications from the Ministry of Corporate Affairs and 4.5 lakh of companies were struck off under Section 248 of the Companies Act. Now, appeal can be filed before NCLT under Section 252 of Companies Act. Thousands of appeals are preferred. Benches having the same strength. Companies Act, now IBC, and then appeals under 252. I mean, the benches were absolutely overloaded. NCLT became, I tell you, as a recovery tribunal under Insolvency and Bankruptcy Code. Every creditor having 1 lakh and above of the debt, outstanding default, is approaching NCLT not for the purpose of insolvency of the company, but for the purposes of recovery of the outstanding dues. So that actually happened, and NCLT, in addition to this, is grappled with merger and acquisitions, operation mismanagement, winding up, liquidation, voluntary liquidation, and now even personal guarantors to corporate debtors are also within the ambit of NCLT. So much of work is already there with NCLT. And if you see the latest newsletter of Insolvency and Bankruptcy Board of India, as per the latest newsletter, out of total 1,942 cases, 1,442 cases have already crossed the outer limit of 270 days under the code. So whether NCLT is giving the desired justice to the stakeholders, my answer is big no. For last 1 year, some of the cases have not even been listed once. What to talk about disposal within 14 days or disposal entire CIRP to be crossed within 180 days? There is not even one single hearing in hundreds of cases there. So when we have all this, I think the entire infrastructure has to be robust. The government must come forward. The government must forward to have this adequate number of benches. And as Mr. Manas Chaudhary said that members, whether judicial or technical, must have domain knowledge. We must have that. Then there is a need for training and colloquiums for these members to update them about the latest developments in the corporate sector as well as in this law. Better staff is the need of the hour. I tell you, in one of the cases, I was talking to one of the members of NCLT, and what he said, that 1/3 of my time goes into the editing of the orders because we do not have sufficient or good number of stenos with us. So what we require at present is technology. Best of the technology can do wonders in this field. And today's two major developments I would like to discuss, that in today's Supreme Court, before one of the benches where Justice Chandrachud was presiding, and matter was going on, Senior Advocate Ranjit Kumar and Mr. Kapil Sibal was there. Both of them were there. And actually, abruptly, Mr. Ranjit Kumar was disconnected. So Honorable Justice Chandrachud said that very soon in the next week itself, I'm going to invite tenders. We have already floated the tenders. And what I want, that once this tender is finalized and I'm the chairperson E-Committee of the Supreme Court, I'm going to undertake one global tender for the entire judiciary in India. So entire judiciary in India now going to be digitized. These virtual hearings will not face any problem. If they do not face any problem, then certainly we are going to have speedy disposal of the cases. And even in today's newspaper, you must have read that the Ministry of Corporate Affairs is also deciding that all virtual board meetings and virtual AGMs and virtual EGMs are also going to be permanent. So what we need is lawyers, no problem. As far as courts and staff is concerned, no doubt we need good number of members, good number of staff, having domain knowledge and best of the technology. If we have best of the technology, I think future is bright for the purpose of this tribunal as well as NCLT. Thank you very much. With this, I'll close and I'll be open to the questions. Thank you.
So thank you, Mr. Madani. In fact, it was very useful. And, you have identified the point that technology has opened up a vista of opportunities. So, but at the same time, you also spoke about how these tribunals are actually overburdened. But on the positive note, I think that, the virtual kind of hearing will go on even post-pandemic time. So at this moment, since Dr. Bhasin would like to leave, I would like to request Mr. Bhasin to make any kind of comment or any kind of, any tangible recommendation to the government of India with respect to the reforms or whatever. Sir, I think you have got 2 to 3 minutes.
Yeah. So my only humble suggestion is that we have to improve the standards of legal education in our country in order to have better lawyers and better judges. Our national law schools are doing a great job, but then that is not, we have mushroom growth of law schools all over the country who are distributing and gifting away law degrees, you see, to lawyers who then practice in the courts. What needs to be done is a strict control on the legal education system, where, of course, the Bar Council of India has the main role to play as the regulator, but also the Ministry of Law and Justice also has to step in to ensure the quality of legal education in our country so that we have good lawyers, good judges, good in-house counsel and good corporate counsel. Thank you. Thank you.
Thank you, sir, for your useful comments. We will anyway continue with the discussion, and we will also share the document with you, where we will draw with some kind of a recommendation or output from this particular meeting. So thanks again.
Thank you.
Yeah. So let me now invite Mr. Manoj Bharadwaj. Manoj has been involved, I think, in several transnational or maybe trans-border consulting services. So Manoj, in your opinion, is the Indian legal profession or Indian legal services sector at par with the global competitors or counterparts? Which are the areas where we have a comparative advantage? And where do you think that we should ramp up and invest our resources to make our legal services sector one of the most vibrant in the world. Manuj, I think you are muted. Can you unmute?
Am I audible now?
You are now, yes.
So I was saying that thanks to DOC and Quality Council of India for putting up this fantastic discussion, and thank you for taking the lead to moderate this session. About your questions, I would say so. My opening remarks would be focused on and will be shepherding one of the required reforms, because there are a lot of structural reforms required in the legal services sector. But I'll be talking majorly about the liberalization of Indian legal market. So, if we talk about the knowledge and delivery of solutions, as your first question said, like the global counterparts and everything, I would say that without a doubt, as professionals, we are competent and at par with all the global counterparts. But in terms of infrastructure, technology, reforms, and the maybe ease of doing business or ease in the legal services sector, sadly not. And there is a very thin line we need to understand, that legal professionals are competent, but can we say the same for our legal services sector? My answer is no. Maybe a blunt one, but it is a no. Coming to your second part of this question about the competitive advantage. India is a big market. The entire world is investing. Legal services are required, and there is a huge opportunity to generate employment and revenue. But this competitive advantage, I would say, will work, but only when we have the competition. And which one of our fellow panelists, I think Mr. Manas Chaudhary, has mentioned that the competition is not there. And he's one of the very competent person to say that. And we need to understand that India has a large talent pool with around 1,200 law schools in India and around 70 to 80,000 enrollments per year. But are the young lawyers getting a job? Or I should reframe my sentence, that are they being paid equivalent to what they have spent on earning that knowledge and skills? Maybe the LLMs from top institutions in India, US, UK, Europe, Australia, wherever. So this is a question of productivity. And when we are talking about productivity and quality, we should have a focus on that. And I mean, amount of input being put in and is nowhere, like the output coming is nowhere equivalent to the amount of input which is put in terms of quality and productivity. And very sad to say that we have seen what happened with young lawyers during the COVID-19 lockdown period. So that's the second question addressed. The third part about investing resources and attaining and maintaining global competitiveness. Dr. James, your question has the answer in itself. When we talk about the global competitiveness, we have to work with the global market and not in isolation, which is happening right now. And moving on and shepherding again my comments to what I really want to address, that India is an important destination for foreign direct investment. And as transnational firms continue to engage in business and investment, disputes involving businesses, corporations, investors, and sovereign states have consequently risen up. In recent years, call for strong and efficient reforms, including the liberalization of Indian legal market, have become very prominent among the stakeholders. Maybe in India's business and economic regime, and also obviously the legal sector. Making the market more liberalized or liberalized, I would give government some credit after the fly in and fly out thing. This process is a continuous process and could be the first among the many structural reforms needed in the Indian legal service sector today. Now, all of us here accept that, at least from what I've heard from my fellow panelists, the domestic, regulatory, and enabling environment has not often kept pace with changes that have happened in the other parts of the world. As other countries, and being such a big global player, India should also consider liberalization of legal services to allow foreign lawyers and law firms to practice law in India. And that could be in a phased and regulated manner. And why? We need to understand that why there is a need of that. Because an open and well-regulated legal profession will not only boost foreign investment, but will also facilitate cross-border movement of professionals, businesses, service delivery, and again, increased quality and productivity. And I'll come to that, how we'll achieve quality and productivity according with the liberalization. India at this point of time must emerge as the legal service capital to the world, at least in the Asian and African region. And this would require an enabling regime which encourages global participation, scalability, and growth in the legal services sector in India by again opening the doors, removing the barriers for foreign lawyers to practice, or at least come to India to work along with the peers in India. No one can deny that India is uniquely placed today. Regionally, if we talk about in the SAARC region, in the South Asian region, India is the fastest growing leader in Asia and Africa. And like most of the sectors like medical, IT services, skill development, infrastructure, reforms in the Indian legal services must be driven to make India the service capital of the world for legal services sector. And talking about Asia and Africa, we can think about a bigger picture. For example, Commonwealth. And why I'm talking about that? Because I've been involved with various meetings of Commonwealth pertaining to legal services. As we share the same legal background with all the 53 members of Commonwealth at this point of time, we could channelize that. The 4 big developed markets are part of the Commonwealth, namely the UK, Canada, Australia, New Zealand. And I remember, I think from 2018, the Commonwealth Heads of Government meeting in London, where I was present. I put that proposal on behalf of India as an individual, not representing the government, to be on the record. I propose that if we take example of European Union or some ASEAN or some other groups, if we channelize the power of the legal background of Commonwealth, we could do wonders, and we could start talking about the liberalization of Indian legal market. And if we want to do that, at least we should have a discussion. And I feel that there is a lack of discussion globally, and India has not been a part of a lot of discussions when it comes to the liberalization of Indian legal market. And again, the Indian government or the Indian authorities would say that it's about reciprocity. So let's start talking about it. Let's start talking about the reciprocity with the other governments. And very shortly, I would have put the benefits of liberalization, that why it is important. So firstly, it will increase overseas deals, inward investment increase, more jobs for qualified young lawyers, maybe setting of minimum wages, increased competition in quality, and again reciprocity benefits in other jurisdictions, professional approach towards the legal service, more check and balance, and obviously with the exchange of knowledge and capacity building, the improved dispute mechanism system. Therefore, I believe that it is a high time to take call on this issue. And I'm of the view that opening up of legal market, liberalization of legal market in India to foreign lawyers in the field of practicing of law, or diverse international legal issues in litigation matters and international arbitration cases would go a long way in helping along services growing in India to benefit the lawyers both from India and abroad. And it is noteworthy, it is very much noteworthy to that the standards of Indian lawyers and proficiency and grasping the intricacies of law is comparable with the international standards, and the legal fraternity in India is not likely to suffer any disadvantage if the law practice in India is open to foreign lawyers, or maybe in a phased manner, in a well-controlled manner and regulated manner on the principle of reciprocity. Just to conclude, I would say that in case we sleep over the matter, the legal fraternity of India may be left behind in providing legal services to this fast-growing class of service seekers in the field of law in India and the world. And let us ensure that the opportunity for creating a hub for such legal service in India is not lost. And this webinar is very much timely, especially in the time of COVID-19 or the pandemic. Many countries have already allowed the foreign lawyers to practice foreign law and diverse international legal issues. We see the latest example, Singapore, and like what Singapore has done has come up with a regulatory body. I mean, they have gone to such a thought process that they have a regulatory body which only focuses on regulation of foreign lawyers and which helps the business community of the country Singapore. So we could think of that. We could think of a legal of an authority, of a body which would work and only be focused on the foreign lawyers and foreign law firms regulation. And I would conclude by reiterating that while talking about all the reforms, maybe liberalization or any other, the process behind these in the legal services sectors, apart from any other consideration or commitment, should also be driven by national priorities and considerations, so that we do not leave behind the rights of our brothers and sisters, the lawyers of India. So thank you very much, and questions are welcome. Thank you, Dr. James. Over to you.
So thank you, Mr. Manoj. I think thank you for sharing your perspective, which is based upon working in multiple jurisdiction and advising international clients. If I remember correctly, there is a certain amount of reciprocity between Indian regulatory agencies and foreign law societies, I think. A large number of Indians are already practicing in some of the big cities like London and Singapore and many other cities. So this is one area where I think it will be useful for somebody else to throw some light, especially with respect to the nature of reciprocity that we have. So now let me actually turn to Mr. Vineet Aneja. So my question to Vineet is this. So there's a certain amount of fierce international competition in the legal services sector. What steps are required in your view to upgrade the Indian legal services to attain international standards? And from a quality and productivity perspective, what do you think about the certification of advocates and law firms in India on the basis of prescribed standards? Are there any voluntary standards which we can meet and which we can provide in order to help the Indian law firms attain or maybe compete with international peers? Over to you, Mr. Vineet.
Yeah, thank you, James. Thank you, QCI and DPIT for setting up this event. We've talked a lot about the opening of the sectors and what we require with respect to the courts. I totally agree with all those. I'm going to touch on a slightly different topic, is what are the underlying opportunities that maybe we can look at today, and what assistance can come from the RPs, our in-house counsels, from the colleges and from the government. We have talked about that the Indian legal industry is roughly $1.5 billion. Seems a large amount, but we are also the second largest legal market with over 600,000 lawyers. Compared to the number and compared to the revenue, we're not even 1%. The projected legal industry for 2021 is somewhere around $780 billion. Looking at $1.5 billion, this was in 2018. Let's say even if you were to touch $2 billion, we're still somewhere around 0.002% of the total global market. Yes, the total global market is dominated is not evenly spread. It is dominated by the US legal market, which accounts for roughly 45%, and the UK market for 10%. But what is the reason for that? To open up competition, we can look at opening up the barriers, but at the same time, we need to look at lesser restrictions on Indian law firms in what they can and what they cannot do. I think we all agree with Mr. Bhasin's opening statement that Indian lawyers are second to none. It's a matter of why are we not looked at as the primary lawyers? How many Indian law firms or Indian lawyers are leading transactions globally? Mr. Srivastava also highlighted three distinct sub-areas: lawyers providing cross-border legal work to clients, lawyers providing primarily domestic legal services, and legal process outsource. There are still areas where we can look at exploiting our legal services, the talent that we have. We are churning out 70,000 law graduates every year, some of them are in fact going to foreign law firms to practice and work and ultimately working in foreign jurisdictions. The areas which we need to look at tapping, and even if we were to increase our market share by 1% or 0.5%, that adds to roughly another $1.5 billion. We advise clients in relation to India. We advise clients in relation to investments, in relation to disputes, but very few of us are actually advising our own Indian corporates or even international corporates in relation to international deals. I'm sure many firms have witnessed that. We've also seen it, but ultimately that aspect comes with once you develop the trust with the client, who will then take you to other jurisdictions. What can the government do? What can we do? I think it's a collective effort. It's a collective effort on the part of the in-house counsels, the law firms, the QCI, the Society of Indian Law Firms, the government, to increase the visibility of lawyers. We are doing Indian transactions. We need to look at how we can increase our visibility in the international market so as to be international counsels and not just Indian counsels. Yes, we have a big benefit to us. I agree. The $780 billion US being the bigger market, yes, their rates and charge of fees is much more as compared to the Indian market. But then we can leverage on that low cost space and look at entering into deals. I agree with Ms. Kaur in relation to the academic side of it. The $1.5 billion which is there, that is also broken up more towards the non-contentious side as against to the contentious. And I think the focus still in our legal education system is more on the contentious side as against the non-contentious side. The institutions should have some systematic approach to also focus on moot, for example, moot negotiations, moot diligences, moot transactions. I mean, we have standards of agreements, but how many of us students actually look at the joint ventures which are really carried out? So when looking at certification, I mean, it's very difficult to certify the standards of a law firm. I mean, there are some firms, there are ISO. ISO does look at some form of certification for law firms as well, but that is more in the service sector with respect to the internal procedures which are set out. We can look at some element of certification. Perhaps the QCI maybe wants to put together something which adds more of a recognition that yes, there are certain elements of certification which a company is looking at, but very difficult to put it on as something which is mandatory for law firms. Ultimately, I think we all agree, a lawyer's advice is all subjective and a lawyer's advice is right until proven wrong. So it is very difficult to actually have any particular advice or standard as to if an international law firm is approaching a client, an agreement in a particular way, an Indian, can we match that? I mean, a simple example, and the US like to do their agreements left aligned. We like to justify it. That makes no difference in the agreement. Ultimately, the agreement is all based on situations and facts, and very difficult actually to really compare what standards can be set for any particular law firm, especially when it comes to imparting legal advice, because that's all subjective. But at the same time, I think we all need to acknowledge that law is a business and we need to look at how we can make growth in that business. I think my earlier speaker made a comment with respect to the financial position of lawyers. I agree. The financial position of lawyers, we need to look at how we can have law graduates coming out, getting good pays in Indian corporates, in Indian law firms. But then really requires us to up the ante and increase our quality of legal services and tap into the international market. At the same time, giving the international lawyers access to the Indian market, but it's a collective effort which needs to be made by all the stakeholders involved. Thanks, James.
So thank you, Vineet. I think a very useful and very structured perspective. I also tend to agree with you that the market reputation of lawyers actually matters more than any kind of a certification given by any kind of an organization. But while coming back to some of the other important issues which you raised, especially with respect to the very marginal presence of Indian law firms or even Indian lawyers in transnational or maybe outward transactions, international transactions, that is something which, in my feeling, we need to address. Our law firms and our lawyers will have to address on a priority basis, because there is a huge amount of revenue, and if we can actually get even a part of the revenue, that can make the size of our Indian legal sector from 1.5 billion to even greater heights. So now let me turn to Mr. Ankur Srivastava, working with ESFY law firm. So the one important, I think, component of the legal service sector is dispute resolution, which includes arbitration, mediation, and litigation. So I would like Mr. Ankur to talk about the various impediments faced by the alternative dispute resolution sector in India in achieving efficiency, productivity, and scale in India, and what are the possible solutions. Over to you, Mr. Ankur.
Could you unmute yourself, please?
Is there any difficulty in? I can't hear actually.
Good evening, everyone, and thank you, Mr. James and QCI. The question which you asked is very important, and this session is also very important because our Prime Minister is most talking about the ease of doing business in India. And when we talk about ease of doing in business in India, then certainly a legal profession come into in a big way, because however, when we see the legal system in India, and most of the clients what we see there is a delay in the justice. We talk about, our fellow panelists have talked about lot of things about the things, how the legal system is evolving, but still there is a delay. So let me just discuss what are the probable reasons for the delay in justice. Some of the points are already in public domain, like there is a vacancies in the judges positions. Then there is a judge-citizen ratio. This is a very important thing. Right now in India is something, judge-citizen ratio is almost 50 million to one judge in India. Optimally, it should be something around 10 million to one judge. So with the fewer number of the judges, the delay in decision making is certainly there. Prior to me, Mr. Madan has tell us how the NCLT functioning is affected due to the overloading and restriction in the number of the benches. And there is a lot of courts are not available. When we talk about the Supreme Court recently, there is Supreme Court. Yesterday only there was a news that demands are being made to set up benches in the southern state. Similarly, NCLAT is there. So NCLAT, one bench is recently set in the Chennai. Otherwise, for every litigant, he has to come to the Delhi for everything. Another things which even the CPC has tried to resolve, that is the frequent adjournment in our Indian legal system. So we are very used to the basically the amendment in the CPC has allowed only 3 adjournment, but still when we see there are different adjournment, whether it's from the side of the litigant himself or the opposite party, because what we say in the famous dialogue, tariq pe tariq. Then another important thing, that there is a transfer of judges in between the cases, and then it lead to the, against if the reconstitution of the benches happen, then the matter has to be here again from the very beginning. This again delay the entire process of the litigation. And like over the period of time, our Indian society has become a big litigant. So there is a huge number of appeals. So we have a different hierarchy of the courts. And now there's a position has come till the matter reaches the Supreme Court or ultimately decided by the Supreme Court. Nothing is finalized. So we move from the city civil courts to the high courts to the Supreme Court, and it goes on. So a simple matter which can be resolved maybe there are 1 or 2 years, it go over for 15 to 20 years. Then again a problem which is happening, there are multiple laws and multiple forums. I can give you a very simple example. IBC was come with a thing that it will resolve all the insolvency and bankruptcy cases. And there was a section 14 of the IBC which talk about the moratorium, that any during the IBC CRP proceeding, no other legal cases will be filed, or so that proceedings can be finalized and their closure happen within the prescribed time. Then we have a separate proceeding under the PMLA code. So in most of the IBC cases, we have seen that there is a moratorium, but ED simultaneously attaches the assets of the corporate debtor, and there is a resolution plan itself. And in between this litigation happens. So the matter which has to be resolved maybe in 180 days or 270 days is getting litigated. Investors sometimes run away, or it reduces the value of the corporate debtor. So this multiple forums and again leading to the delays. So then the simple matters like delay in filing of the written statement, increased litigation, and my fellow panelists have already said something. There are more than 4 crore pending cases which are there. So this is all we know. These are the various problems in the Indian judicial system. But to make it to the world-class legal system and to make it a captive legal market for the entire, what should be the things has to be done? So recently there was, earlier, there was amendment made, and there was a Commercial Litigation Act has come, which provide that any litigations of commercial nature, which is going into the file into the High Court, a prior mediation process has to be followed. So I think that it can be a good solution, so that in all the cases of commercial nature, at least, mediation has to be made compulsory in a time-bound manner. And if it's not happening, that if the person is filing an appeal or is not coming, then he has to pay some fees and all those charges to go to the High Court. And also the High Court, in the High Court or Supreme Court, the constitutional matters should be has to be taken separately. And when we are talking about the commercial court, like the NCLT, corporate matters has come. Similarly, the benches are to be specialized in the commercial courts, and they have to deliver in the time-bound manner. So one thing is the mediation has to be made compulsory if in all the commercial dispute. Secondly, if we have to evolve further, apart from the mediation, arbitration is again one of the things which a lot of time Indian government and their things has tried to make it a very robust system. A lot of amendment has been made, like the arbitration proceeding has to be completed in 1 year. A lot of provisions have been introduced, but the result which ought to be come out of this proceeding is again not coming. Instead of making the litigation more easy, arbitration proceeding are itself becoming one letter adding to the litigation. So whoever party lost the arbitration, they go for the appeal and again appeal. So if they directly go to the High Court, the matter can be resolved shortly. But they will consume time in the arbitration proceeding. When the arbitration award has come, then they again go for the appeal. So these are the lacunas where we have to address the system. How to address the system? Government are coming from the framing the policies, but as a legal professionals, we have to come with more research papers with our practical experience. Like this session is happening, so a lot of these sessions, sort of things from the legal experts, and we should help the government in framing the laws rather than it should coming from the government only. So these are the few points which we feel that should be done to reduce the timing which is consumed in the litigation. And mediation and arbitration is to be more promoted, and it should be made compulsorily. Like I remember in the case of the government undertaking, there was a system was built in that if there is a dispute between two government departments, they should not go to the high courts initially. There is an interministerial group. They should refer the dispute to that group. They will mediate, and if matter has to be resolved there only. So those sort of a system has to be evolved, and they should be made compulsory. With this, I am just closing my things. Since the shortage of the time, I am open to any questions. Over to James. You.
So thank you, Mr. Ankur. I think your points are absolutely valid, especially the point that arbitration should not actually lead to more litigation, but to less litigation is an extremely important point. In fact, we are closing towards 6 o'clock, but I think the organizers told me that we have got around 10-15 minutes more. So now let me turn to Mr. Sanjay Gamawat of Dalmia Bharat. Mr. Sanjeev, my question is actually with respect to the structural and other regulatory changes required with respect to the in-house counsel in order that actually the potential of this sector. And the second question is to what extent we can actually use the technological developments and advancements in order to realize the potential of this sector. Over to you, Dr. Sanjeev.
Thank you, James. Thanks a lot, and thank you. I sincerely thank the Quality Council of India and the Ministry of Commerce and Industries for inviting me to share my views. Well, previous speakers have spoken on various aspects of the legal services industry, and I think to start with, Dr. Bhasin has deliberated on various issues, and including on the aspects of in-house counsel's role and relevance. I think let us understand the context. What is the context? What is the legal services industry which we are talking about? And for whom? So we are talking about this legal services industry for an economy which we expect it to be a $5 trillion economy. Forget about the years, whether that is 2024 or 2025 or 2028. It doesn't matter. But the fact is that we would become a $5 trillion economy in the near future. Coupled with the fact that the fourth industrial revolution is underway. And the fourth industrial revolution is changing the way in which we conduct our business, the way in which we behave ourselves. We are talking about an economy which is creating 90% of jobs. We are talking about an economy which is creating or which is generating nearly 80% of government revenues. We are talking about an economy where this private sector, this is contributing nearly 60% of investment. Now, for this industry, can we afford to have the legal infrastructure which we are talking about? And let us first just think about it. Do we really have legal infrastructure? That's a moot question. The existing legal infrastructure in whatever form and shape we have is a pendency of litigation of nearly 3.5 crores cases. So it essentially means what? 3.5 crores cases which are required to be handled by the number of judges which are, from a United Nations norms standpoint, just 20% of the standard norms. UN norms suggest for 50 judges per 10 million population, per million population, we have 10 judges per million population. So from a quantitative aspects, we don't have the right number of judges. So obviously, there's a huge litigation, but then out of this huge litigation, the major part is of the government litigation. Government litigates for whatever reasons. Of course, the one major reason is that they don't want to take risk. There is no accountability left because somebody would be asking them questions. And so you will find invariably the same nature of cases which are originally arising out of the government litigation. But then there is another situation. There's a huge list of those RTI litigants or the PIL litigants. They have nothing to lose. Those people and majority, and just forget about the exceptions, who are perhaps the serious litigants who want to really, raise the serious concerns about the economy or the issues. But then largely those are frivolous litigations. And in which environment? In an environment which is highly regulated. An environment which is highly regulated with obsolete laws at times. But then there is apart from the quantitative aspect of the justice delivery system, we have a major issue on the qualitative aspects of it. And some of my previous speakers did mention about that. Do we really have judges who have the commercial understanding? Are they really competent to give those kinds of judgments and they need to realize that there are huge economic consequences of the judgments which they pass. Now, in a situation where status quo orders or the stay orders are the norm without getting any indemnity in return, you just ask me whether this happens in those developed worlds. Without any indemnity, you get this stay, the projects get shelved for 2 years, 3 years, 5 years, and ultimately those stay orders gets lifted. Now, this is what environment we are talking about. We have orders, whether in the 2G scam cases or the coal scam cases or highway van related issues. And some of the prominent people, they are saying that those particular orders have perhaps also led to an economic collapse as far as the country is concerned. Now, this context can be understood with all these examples. There is an example. Just let me share an example. A matter gets listed, and I think this is the experience of all of us, all members of this audience. Matter gets listed for final arguments. After a few days, when the matter gets, listed and heard, if the court says that no, my board is today full, your matter would take time. And again, the matter gets listed after 2 months. Now, the reality is, if there are 10 parties, then effectively, There's a span of nearly 3 crores to 5 crores. All people are coming with the best of the senior counsels and best of the law firms. Now, if that is the situation for the first, I fail to understand why the matter gets listed. Why don't you have a mechanism whereby administrative issues get separated from the adjudication issues? Let only those matters be listed if you have a time to hear those matters. Why do you list those matters? Some of my members, some of the previous speakers did mention frequent adjournments. Yes, frequent adjournments. It happens. At times parties take adjournments. But then you take advantage of a situation because you yourself has created that situation. The justice delivery system, as well, I completely echo the sentiments which Dr. Bhasin expressed. The justice delivery system is failing. It has in fact failed. There is no sensitivity towards commercial issues, no accountability towards commercial issues. And somebody needs to understand that there is a huge consequences, not only economic consequences, but India as a nation, as we present to the world, are we the right destination in terms of investments? And can we achieve this $5 trillion economy or $10 trillion economy without that technology and without that investment, which we need to attract from the market? Now, in this backdrop, what is the solution? Alternative dispute resolution has miserably failed in India, particularly because of the ad hoc arbitration and also with the coterie of people and the nexus of those people, the retired judges, the same law firm, the same set of people, they get appointed and people don't have enough time to even do justice to this. Forget about the understanding on the commercial issues. So this is what the environment in which the Indian industry is suffering. Now, here is a role, as Dr. James, you asked me about the in-house counsel's role. Here the role comes of the in-house counsel. The in-house counsel is struggling in this environment. And in this environment, the contemporary role, the way in which I see this, and I normally say this, that this is not a role of a person who is drafting your documents. This is not the role of a person who is coordinating with the lawyers. This is much above all these things. Today's role is, and I define it as a role of a strategizer, a role of an enabler, and a role of a protector of business. So I say that this is the strategizer role, it's an enabler role, and it's a protector role of the business. Now, in this backdrop, if you see this profession, I have a limited time, so I will just briefly summarize this. This is one profession which is having a role of a strategizer, enabler, and protector. But just think about it. This role is not coming under the purview of any professional body. It's a profession. It's a profession. But then, is this profession being recognized? Dr. James, just appreciate this. I'm a chartered accountant. My Chartered Accountant Institute allows me to be a member of the institute. There is a separation. There is a practicing members and there are other members. But then still, I'm a chartered accountant. I'm a member of that professional body. I'm a company secretary. Still, I'm a company secretary. I might not be practicing. I'm a cost and works accountant. Still, I'm a member of that institute. I'm a chartered secretary and administrators of UK. Still, I'm a member. I might not be practicing. But then here, I am a lawyer. Bar Council doesn't recognize me. Advocates Act doesn't recognize me. Why? Please amend laws now. This is high time. We are talking about one profession. We are talking about this profession, which is basically catering to the whole business world economy. This is the one profession which is taking care of all compliance issues, which is strategizing on the business part of it. Please, this is high time that this profession should be recognized and acknowledged. And just think about the numbers. What numbers we are talking about? Do we have this kind of strength as far as professional members are concerned? Today, if I take the listed companies, nearly say 7,500 listed companies. If I talk about the total number of companies, say 20 lakhs companies. And if you just average it out, of course, I don't have the authenticated data on that. But then on an average, nearly 3 lakhs to 5 lakhs people would be there in the in-house counsel's profession. Do we not need this profession to be acknowledged in the same manner as the other professions are being acknowledged? There should be the members of the same professional body which they are representing. They are in-house counsel because they are advocates. They have qualified law examination. Now, in this backdrop of the time is up. Okay, no problem. I will just briefly mention, please. I will just briefly mention because you asked me on the artificial intelligence. So I would just briefly mention in terms of my recommendation, what I would be looking for. One is recognition of the in-house counsel. This is my one recommendation. My second recommendation is that the qualitative aspect of the justice delivery system should be strengthened. There should be professionalism needs to be inculcated in that, in the justice delivery system. My next is the use of artificial intelligence, because that would do wonders. The fact is, we are in the fourth industrial revolution. Today or tomorrow, we will have to adopt all these technologies. So the use of artificial intelligence, that would make a big difference as far as justice delivery system is concerned. My next recommendation is that the ADR mechanism should be strengthened only with the institutional mechanism. And last recommendation is that there needs to be a separation between administrative role and the adjudication role of the justice delivery system. Thank you very much for giving me this opportunity. Thanks a lot.
So, Dr. Sanjay, thank you very much for passionately expressing the concerns of 6 lakh in-house counsel in the country. You also rightly pointed out the major issues with respect to the justice delivery system, and also the kind of social and economic impact and implications it has for India. Very valuable and very passionate comments. So now let me turn to Mr. Rajendra Prasad Singh. My question is related to how the legal.
You are muted.
Mr. Rajendra Prasad Singh, my question is related to the modernization in the delivery of legal services sector. My question specifically is whether you think that the modes of delivering legal services that we have used during the COVID-19 period, can they be still used post-COVID-19 situation, or can they actually become permanent fixture of our delivery system?
Thank you, Dr. James, and thanks, QCI. I think the time for pleasantries is not there, and I am being the last speaker. I must stick to the point. When it comes to the relevance of doing ease of business and the legal delivery system, I would say that the laws are made to make our life easier, to avoid confusion in our lives. And when it comes to business, we do it for making a living. So both being related to our lives, there is a direct correlation between the legal delivery system and the ease of doing business. That's one. Your next question is modernization of legal services, how far it has gone, and whether we really have modernized. My honest opinion will be that in the last couple of years, the modernization of legal delivery system or justice delivery system has not been at the expected pace. Of course, during the pandemic period, the modernization or the use of modern techniques and technologies have dramatically increased. And I'm a strong believer of the fact that this virtual hearing or use of latest technologies in justice delivery system will be a great help in times to come. We are talking about legal delivery system, but at the same time, we also must have in our mind the justice delivery system, because legal services are provided by experts, by legal professionals,
but justice is delivered by the judges and the presiding officers. So, and of course, that is based on laws that we frame. So my recommendation would be that the laws should be clear and simple, and it should keep pace with the changing times. The mindset of lawyers and judges and even the litigants should keep changing with the changing needs of the time. And use of latest technology and lot of infusing of additional infrastructure is a must for improving the legal delivery system. Of course, the government has been doing a lot in this regard in the recent past, and the changes in labor laws done by merging 29 laws and replacing it with 4 codes is a quantum leap in post-independence era. And we expect that the kind of changes that have been made will speed up the legal delivery system. But I'm only worried that unless we change our mindset, it should not happen that we again face the same fate as we have faced in case of IBC code or NCLT. With these words, I would thank all of you for giving me this opportunity, and I'm open for the question provided there is time for that. Thank you very much.
So thank you, Mr. for your insightful comments. We have got one more speaker actually. That is Mr. Sugesh Misra from the Competition Commission of India. So my question to Sugesh is, with respect to the role of market regulators in supplementing the rule of law. In other words, what are the prospects of legal regulatory services in the context of a maturing legal service market in India? So over to Mr. Sugesh.
Thank you, James, for giving this opportunity to me. And in fact, the previous speaker was saying that he was last, but not. I am the last speaker. Don't take this credit from me. In fact, rule of law, this is a celebrated term used very widely by us in the legal fraternity, and was coined by sometime back in the last century, by Professor Dicey in his celebrated book, The Law of Constitution. Broadly, it has 3 connotations: absence of arbitrary power, the equality before law, and predominance of legal spirit, and to be established by courts. So when we talk about rule of law, it is something which is very hard to our constitution, and some of the provision or some of the celebrated terms were even incorporated in our Indian constitution. Say, for example, in Article 14. I'll not go into it because time is very limited, and mandate is something to discuss the role of regulator vis-a-vis rule of law. So in terms of competition law, the Competition Act, we have inbuilt mechanism. I will speak about my particular law, that we have an inbuilt mechanism for proper check and balances for rule of law. For example, let me speak with the preamble, which talks about 4 noble objectives why this law is needed. Number 1, to prevent practices having adverse effect on competition. Second, to promote and sustain competition. Third, to protect consumers, and there are n number of laws protecting consumer interest. And fourthly, to ensure freedom of trade carried by the participants in the markets in India. Now, somebody when file an information before the Competition Commission of India, so there are enough check and balances. It is not something that anything can be filed and can be taken on record. So the process is like this, and rule of law will equally come into play, that the prima facie level commission has to satisfy whether a case has been made out under competition law or not. So initially, check and balance that whenever there is any complaint in our parlance information, be it filed by some individual or corporate firm or a reference from the government. So we have to first check whether case has been made out under the competition law, prima facie case. And once it happened, the matter referred to DG for investigation. From getting the report from DG after the investigation, parties were called or their counsels were called, and after hearing the parties or their counsel, the order will be passed. So there are enough check and balances insofar as Competition Act is concerned. This is my first point. The second point, what you have asked about the prospect of legal regulatory services in the context of maturing legal services market like in India. I must tell you, there are, as Manas ji has already have spoken about, tussle between various regulators, and we are also witnessing some of the cases are pending in different courts, including Delhi High Court. There is a tussle between the PNGRB and the role of Competition Act insofar as issue relating to bid rigging and cartelization in petroleum sector are concerned. So matters are still pending there. I should not supposed to speak because they are sub judice. So my say is that the legal service market is still maturing, and there are legal regulatory bodies, they are still new in the market and have not seen the prospective or benefits or complications in the market. Also, even if they are pre-existing, they may not come to the conflict with each other in case their domain of work is quite close or crosses each other. This has been settled from time to time by Apex Court. Still, there are areas that require adjudication or clarification, because one of the speaker was even saying that why not interdepartmental consultation to resolve these kind of issues. These are some of the things which I think maybe in times to come, some clarification will come from the either by way of maybe mutual consultation or by some point kind of proper adjudication to define the role of these regulators, so that they should not impinge upon each area of domain or to create some confusion. So this is what I think maybe I can briefly explain about my perspective on this particular subject. Thank you very much.
So thank you, Mr. Sugesh, for actually, I think completing your remarks within time. Anyway, we have overshot by nearly, I think, 20 minutes. It's almost 20 minutes past 6. But we have got a couple of questions, so I will read it out. The one question is, I do not know the name of the person, but he asked the question. So there are 5 sections under IPR. One is trademark, the second is copyright, geographical indication, and design. Then the question is, why limit our services in patent section where BSc and BE graduates are qualified to practice it? So in IPR itself, there are limitations set. Why should it be removed? Why should it be removed, or why should it be removed? I think, so the point is that I think the person wants to find out whether this restriction on practicing patent should be removed, and should lawyers also be encouraged to practice that particular area. If you can comment on it, I think there is no restriction, but we have to confine your intervention to maybe 3 or 4 minutes.
James, I'll take the liberty of answering on this one, if that's okay with everyone else.
Please go ahead.
Yeah. So I think the question which has been raised by whoever has raised it is in relation to practicing. And in patents, we have a requirement wherein patent prosecution and filing is done through a registered patent agent. And there are certain restrictions to qualify as a patent agent in India. And it is very much akin to what is the process which is being followed in other countries as well. But I think it is a classical case, and it's a very logical question, because prior to this amendment, patents could be actually filed and processed by any practicing professional. And even now, patent owners can file and prosecute patents by themselves. But the patent agent regime was brought in along with the Patent Amendments Act, which was in compliance with largely what are the systems which are there. And as IP laws in India were really, shall I say, not up to the mark to the WTO requirements, India has followed the global trend of quite literally replicating the same process. So which is very similar to Europe as well as in the US, which are the most leading markets for it. And I think government should look at it, because I think the whole idea of putting patent agents is not helping patent filing and processing to be expedited. So it is something worthwhile thinking, because there is no mandatory requirement on a TRIPS level for us to have this kind of a restriction on practitioners. But again, I think it's a very limited aspect. The larger aspect, which I think is about how and in what way the Indian government is implementing new laws. And I think there is a unfortunate trend of looking west or looking at more developed nations and trying to imbibe that process. We got to also see what works better for us in India. And it will really come down to systematic and proper policy measures being taken up at the India level, which make it patent processing quite effective within India. So it is something definitely worth looking at to do away with the patent agent requirements.
Right. So thank you. I think your explanation has been very clear. So maybe since we are running out of time, I would just like to give it may not be a summary actually, but some of the key points that came out from this discussion. One of the most important points which everyone touched upon is actually the staggering pendency with respect to the litigation sector in India. And I think it requires urgent reforms or maybe urgent attention. The second point, maybe it may look like a self-congratulatory, I think, comment that we have second to none, but as a system, we are not actually doing that well. So you have given fascinating comments and suggestions on improving multiple aspects of the legal service sector. And I'm really grateful to you for your comments. And on top of that, I would like to thank the Ministry of Commerce and Industry, especially the Department of Commerce, Mr. Darpan Jain and Manisha Meena within the department, and also the DPIIT, and in addition to that, the Department of Legal Services for organizing this extremely timely and important discussion. So we will make a summary of the document and we'll send it to you, share it with you for your further response and comments on the same. So without further, I think, Ado, let me actually turn it over to Pooja. I'm also thankful to Pooja and Amit from QCI. So why don't you actually conclude this session? Thank you.
Thank you, sir. Once again, a very good evening to everyone. This has been an enriching manthan which touched upon various aspects in the legal services sector. There have been several deep insights and recommendations in today's manthan that will be compiled into a compendium that would help to strengthen the legal services in the country and will significantly contribute to our Prime Minister's vision of Atmanirbhar Bharat. On behalf of DPIIT, QCI, NPC and all our partners, I thank all the dignitaries present here for today's session. First of all, a big thank you to Shri R.K. Srivastava ji for sparing his valuable time and setting up the context, helping us to shape up today's deliberations. A big thank you to Manisha Meena ma'am and Anuj Ojha sir from Department of Commerce for their great support and guidance. We also thank today's moderator and panelists for such a meaningful deliberation. Our thanks to all the participants also for joining us in this webinar, and we hope that the deliberations have been enriching for them. We also thank DPIIT, the Department of Commerce, the Department of Legal Affairs, NIC team, our partners including NPC, PhD Chambers, SEPC, FICCI, SOCAM, CII, and all other partners. I'm not taking all the names as it is a long list. But thanks to all for their support. Last but not the least, I thank the QCI team for their hard work that made this happen. With this, we wish you all a very happy Republic Day in advance. Jai Hind. Thank you.
Thank you. Thank you, everybody. Have a great time.
Thank you.
Thank you. Thank you very much.
Thank you so much, sir.
Yeah.
Thank you, sir. Thank you so much.
Thank you, Pooja. We are formally closing the session.